Good morning. Happy Tuesday. Today is a great day. I learned yesterday that Michelle Barrientes Vela, the most corrupt police officer of a sort, constable, precinct 2 constable in Bexar County, or Bexar County as the rest of the world would say, is under FBI investigation. Oh yes, kids. Oh yes. I'm happy about it. It's always amazed me that the auditors, frauditors, auditards in the Austin area didn't do a goddamn thing about her. She was incompetent from the beginning. I've made several videos on her, and I personally am celebrating a bad cop being placed firmly under investigation. The FBI is in it to win it. They raided her office. They raided her home. Oh, she's not going to have fun. I hope they crucify her. In lighter news, there was a comment that I want to address. Somebody commented that they didn't think there was reasonable suspicion on the U-turn because the person could have been making a U-turn. And again, yeah, we're back on the Earl video. Person could have been making a U-turn for any number of reasons. And while that is a common misconception about what the test is, that isn't it. You got to remember, in Illinois v. Wardlow, there was a young man standing at the corner of a building, sees the cop and runs. Could have been running for any number of reasons. His mama could have called him late for dinner. He may have promised to meet his girlfriend for lunch somewhere and was running late. He may have just been about to start jogging when the police showed up. It might have been just a coincidence that he started running as soon as the police showed up. He might be phobic of the police for no other reason than he's, I don't know, maybe he has seizures from flashing lights. How about that? There could be any number of reasons. The test is it a reasonable possibility that one of the reasons is crime is afoot? And that's what the cops were looking at. And then from there, the whole point of the reasonable suspicion is to allow them to develop probable cause if there is in fact crime is afoot, which means that it's more likely than not that a crime was committed and that person committed it. But it just needs to be reasonable for them to have that suspicion. That's why it's called a reasonable suspicion. It has to be supported by articulable facts, but it just has to be a reasonable suspicion. They don't have to have every other potential excluded in order to proceed with a detention. So I hope that helps out that little misconception. And finally, we're going to go back to my favorite sob stick. Gosh, he's the gift that keeps on giving. One of the reasons why I don't normally cite to attorneys' websites is because they are trying to summarize cases. And they are also trying to hook people in. This guy's giving me an out. I'm going to go in and see him. I'm going to go in and retain him because this guy's the guy who has the answer. He knows how to get me off the hook. So after the quote that I provided that dealt with actual officers having reasonable suspicion that somebody was evading a checkpoint, he went on to say, the attorney went on to cite State v. Hester, I think it was, and which held that reasonable suspicion of an illegal U-turn, where there was no illegal U-turn, and there also was no reasonable good faith mistake of fact or law, is not something that the police can stop you for. Because in State v. Hester, there was a roadblock, there was a hill, and there was a flat part below the hill in front of the roadblock. So people were coming down the hill, they'd get to the flat part, and then they would proceed into the checkpoint. The officer testified that the only reason he stopped the vehicle is because it made an illegal U-turn on the hill. It's illegal to make a U-turn on a hill in Georgia, apparently. Or at least it was when the decision issued. Now, the the driver of the vehicle said no, he made the U-turn on the flat part down below. Now, the cop's basis is that it's illegal to make a U-turn on a hill. The trial court chose to believe the driver and not the officer, which I'm sure is or should be making some of your heads explode to think that a court may, in fact, believe the citizen and not the officer from time to time. It's almost like their credibility is being judged, and it's not just a pass. It's not just a pass for the boys in blue. Kind of makes you think. But anyway, so the court found, as a matter of fact, that the U-turn was made on the flat part. U-turn was made on the flat part. The guy was arrested because he made a U-turn on a hill. No reasonable suspicion. He was not arrested. He didn't make a U-turn where the officer said he made the U-turn. Therefore, the officer didn't have a reasonable suspicion. He didn't have a reasonable good faith mistake of fact or law. Now, the court in State v. Hester, after pointing all this stuff out, or before pointing all this stuff out, says this isn't a case where the officer is basing his reasonable suspicion on an evasion. In fact, the officer stated that the only reason he pulled over the driver was because of the illegal U-turn. He did not suspect the officer was evading the checkpoint. So the court said this isn't a case where there's reasonable suspicion that the guy was evading. So we can't use the tried and true, the general standard, the normal test that unusual or abnormal actions taken to avoid a checkpoint give a cop reasonable suspicion. It literally says, even if it's otherwise legal actions that are abnormal or unusual taken to avoid a checkpoint give cops reasonable suspicion. That is exactly what I was saying. That's exactly everything I've been saying. The very thing that my Sovsit friend, who believes that he's too smart, thought would undermine me. He asked me for a mea culpa based on that. Funny. I wonder if I'm going to get a mea culpa from him. But no, that's the difference. It's what the cop based his reasonable suspicion on. Remember, the cop has to have a reasonable suspicion, and he has to be able to support it by articulable facts. And it's just enough that it would warrant a reasonable person to think that, yeah, there might be something to that. You should check that out. It's a very low bar. It's a very low bar. Again, back to Illinois v. Wardlow. Guy sees the cops and runs. Reasonable suspicion. Checkpoint. Guy sees a checkpoint and runs. Reasonable suspicion. Now the state can round that up. It can change that because the Fourth Amendment's the floor, not the ceiling. But the floor is basically one pubic hair above the ground. I mean, it is not a leap. If the officer in State v. Hester had said, I think he was trying to avoid the checkpoint because he saw the checkpoint and he made an unusual or abnormal U-turn where people don't normally make U-turns, leading me to believe that he was evading the checkpoint. Hester would have been an entirely different decision. It's based on what the officer says. 9 times out of 10, if there is no reasonable suspicion, it's because the officer's too stupid to say the right words. Seriously, it's a very low bar. And that doesn't mean that I'm happy about that. That's the way it is. One thing that people need to start doing, which they never will. I mean, people have been people forever, and people will continue to be people after I make this video. And all, 500-600 people who watch this video will either be doing it already or won't change simply because of this video. But what people should do is they should make their beliefs comport with reality. It is a very weak legal position if you're trying to take a quote out of context from a case. You're ignoring the rest of the case and you're ignoring all the other cases on point. It's a very weak legal position. That's why Mark Stevens has such bad luck. He's a sovereign citizen guru. And what he does is he cherry picks quotes out of random cases from all over the place, trying to make it sound like you have a constitutional right to drive and that they can't take that right to drive away from you. They can't turn a right into a privilege. And he cherry picks lines out of disparate cases, disparate, unconnected cases that have either no bearing on the current state of the law, or they have no bearing on the subject matter. Like, oh, you can't turn the right to practice medicine into a privilege or something like that from an ancient case. So that is a literal sovereign citizen tactic, taking texts out of context, taking citations out of context from the greater text, and ignoring reality. I'm not saying that my favorite sovereign citizen is a right to drive or right to travel kind of person. I don't know his concept or his notions on that, and I don't really care. But that's one of the things that sovereign citizens do, is they ignore reality. Reality says you keep getting arrested for driving without a license. You keep getting convicted of driving without a license. It must be that it is against the law to drive without a license. Just because you think in your opinion, the Constitution says you can drive without a license, and that's your opinion. If you are using case law to support your opinion of the Constitution, and judges who make case law are disagreeing with your interpretation of it, well, your interpretation probably isn't right. Stop ignoring reality. Everything needs to work together. And if it doesn't work together, then other people will have probably pointed it out as the exception, not the rule. Like Bivens is the exception, not the rule. Anyway, thank you for watching. Have a great morning.